storm. I know it just passed through Jackson. I saw that a tornado was spotted, and I'm really glad that we decided not to have the hearing at the courthouse downtown. I don't think we could have anyway, but so thank you all for being here. As I understand it from the court administrator, is Nikki Lloyd is our court reporter. Nikki, I see you. Is that you?
Yes, so that's me.
Okay.
And we also,
beg your pardon?
I said the mayor is also, my understanding is Amy Key is also a court reporter. My understanding is the Mayor Labumba's attorney got his own court reporter.
Yeah, that's fine. Everybody can have a court reporter if they like. No problem. So my records indicate that Felicia Perkins and Jessica Ayers represent the mayor. Are they here?
Good afternoon, Judge. Felicia Perkins here. Miss Ayers has been affected by the storm. So I'm trying to see what her status is. Last time I talked to her a few minutes ago, she had no lights and the storm was passing over. But
are you prepared to go forward?
Actually, no, Your Honor, and that was a problem, and I just found out just a few minutes ago. So she was the one who was going to argue our motion, and so I don't really know what the court would want to do with that.
Well, I will delay as long as possible so that you can try to get in touch with her and have her joined up. We're going to be a while.
Okay.
And I'll delay it as long as possible so that you will not miss an opportunity to have her. And if you can't, then I know how smart you are. You'll be able to give us the mayor's position in this. And of course, you filed an excellent brief.
Right.
And so I don't think we'll miss anything, but I really do need to get this hearing conducted tonight. So
right.
Deshaun Martin, City Counsel. Mr. Martin, are you here?
Hey, Justice. Good afternoon. How are you?
I'm good. How about you?
Judge, and my spoiled children are in Florida, and so I said the lights go out when it looks bad. I said, I'm going to stay in Jackson. I'm at the office so that the court knows and everybody else knows Councilman Foote is in my office. Also, the clerk. I just wanted the court to know who was listening in the office, not visible, Judge.
No problem. I think I announced at the last hearing we had, I think in this case, but my view is that the courts are open to the public, and anybody that wants to hear what goes on in our courtrooms is certainly welcome to do that. We should make every effort to make sure that the public is informed and has an opportunity to hear the proceedings. So that's perfectly fine. Katoria Martin, representing the city of Jackson. Ms. Martin, are you here?
Yes, Your Honor. I'm here along with Terry Williamson.
All right, welcome and thank you. And Chase Brown, I see you here on behalf of Waste Management. Robert Gibbs, I see you here on behalf of Waste Disposal, and John Walker on behalf of Richards. Mr. Walker, you're
along with Gloria Green, Your Honor.
All right, very well. So you all have given me a great deal to read, and I've read it all. I've read the briefs, and I know what I'm interested in hearing you talk about, but I don't think I'm going to limit you unless I just don't want it to go too long. We've got potentially 6 attorneys making arguments, and I know how that goes. And I know you don't want to all stay here till midnight. And so I know the facts that are undisputed. I know when the resolutions were passed. I don't pretend to have an opinion yet as to the legal effect of everything, but I know what happened when the council met. I know when the mayor declared an emergency and those background facts. And so this lawsuit is going to focus on the mayor's complaint. He filed a complaint, and the city council filed an answer, and we're going to focus on that complaint and that answer and the relief that the mayor requested in his complaint. That may lead to other things, but I view my job here as to as a responsibility to address the issues raised in that complaint. I apologize to the intervenors. I did not make it really clear the conditions under which I had allowed intervention. The reason that I allowed intervention of all three intervenors is because they certainly have an interest in how this resolves, and I would like to have the benefit of their argument and their view on the issues in the case. But what I'm not going to do is allow new issues to come in from intervenors. In other words, if Waste Management or Waste Systems or Richards wants to file a separate lawsuit based on a claim that's not in this litigation, they're certainly welcome to do that, and they could do it as a result of what we do here, or they can do it whenever they like. But I'm going to resolve the mayor's request for a declaratory judgment on the issues that he's listed in his complaint. And I guess what I hope will be made clear to me tonight is the question of whether any contract at all exists that can go forward, whether anybody has complied completely with the law that allows a contract with any provider to go forward. And I have in mind the statutes that control the Constitution's requirements and the separation of powers issue, and the question of whether the core requirement that the executive negotiate and propose a contract and the council approve it. That's a beginning place. I know there are a lot of permutations of how that can go forward, but I'm looking for a contract that the executive, the mayor's office proposed and the council has approved, or a contract that has been put into place through another system or another method that is allowed by law. So those are two things I'm looking for so far. And with that, since Ms. Ayers is not here, Ms. Perkins, you tell me if you're able to contact her and she gets here. But I'll move first of all to Deshaun Martin. Mr. Martin, let you give me the city council's interpretation and application of the law to the facts that are before us, if you will.
May it please the court, Judge, can you hear me now?
I hear you very well, sure.
Oh, all right, thank you, Judge. Judge, I heard your questions, and I'm going to get to them. I also did the questions 1 through 7 that you sent in an email and said, look, this is what I'm looking for. Is it
Correct.
okay, Judge? That's what yes, sir. Number 1, your question, and Judge, forgive me for not standing, and I don't have on my jacket. I know that your local rules are decorum, but I'm out of decorum. Please forgive me. Is that okay?
That's certainly fine.
All right. Number 1, whether the mayor had authority to execute a binding contract on behalf of the city of Jackson without approval from the Jackson City Council. Our rendition to that answer, Judge, is no, he does not. Number 1, and most pressingly, Judge, is that under 3315 5G, no contract, there was not a local emergency. The local emergency statute defines fire, water, earthquake, hurricane, shortage, natural disaster. Mrs. O'Leary's cow, Judge, up in Chicago didn't kick over land and half the city didn't burn down. We didn't have Camille number 3. We didn't have Katrina nor Rita to come through our town, Judge. Sections H and I go on to even further define emergency, what emergency is, and when you have a local emergency. The conditions were within the city of Jackson at this time. We had the awful coronavirus from Wuhan, Hubei province, China. But Judge, it was on the tail end of the virus. There was ample vaccine when this alleged emergency popped up. You go forward through the statutes, and this statute, there was not a valid emergency for this contract to be issued. Judge, also under that statute, it says that conditions, it says that Section 3315 5G requires that the emergency conditions be beyond the control of services, personnel, equipment, or facilities of the political subdivision and require the combined forces of other subdivisions or the state to combat. And we don't have that here, Judge. We don't have that necessary emergency to even declare one, to give the mayor some authority to do whatever he thinks he has the authority to do. Also, the Mississippi State Constitution, Article 1, Section 1, Section 2. Judge, I ought to get a gold star because I've been doing some research and it popped up your estoppel case with the tree house, and that was an excellent opinion, Justice. The tree house case and estoppel. The Constitution of the state of Mississippi still matters. Section 1. The powers of the government of the state of Mississippi shall be divided into 3 separate parts, and each of them confide to a separate magistrate, to wit, 1, legislative, 2, judicial, and the other an executive branch. Those branches of government in the state and in the city still do matter, Judge, and they are of most importance. Judge, also looking at the form of government that we have here in the city, we understand that we have mayoral council, and in that mayoral council form of government, the legislative branch is vested with the council, Justice. The executive branch is vested with the mayor, and those rights shall not be trampled upon. Justice, excuse me. Also, looking at the individual contract issued by the mayor of the city of Jackson to Richard's disposal. Paragraph 2 says that the contract to proceed shall go forth within 14 days of receipt of a fully executed agreement approved by the city council and or authorized by a court of competent jurisdiction. Judge, none of that ever happened. Richards got no more than 2 votes ever in this matter. That the actual force and the power extended through the legislative branch, i.e. the city council, still matters. Judge, we ask you to go back to regular order, majority rules. We are a democracy, and we need guidance of you, Judge, Justice sitting as a chancellor.
Mr. Martin, let me stop you just 1 second, just so I can keep my thinking straight. There's so many issues here and so many parties. Let me just stop you 1 second. Ms. Perkins, I want to ask you a question, if you'll unmute your microphone. I read again today the complaint filed by Mayor Lumumba, and I do not take it from that complaint that the mayor is taking the position that his contract that he signed with Richards can be effective and enforceable absent approval of the city council. Am I reading the complaint incorrectly?
Well, this was the intention of the complaint, and this is the mayor's position, that it is a valid and binding contract. Okay, the mayor can negotiate and execute a contract on behalf of the city council, on behalf of the city of Jackson. However,
let me stop you because I'm going to let you. I don't want to take up or encroach on Mr. Martin's time. Okay. I just wanted to make sure I understood whether that was an issue. It's an issue. I'm going to certainly let you argue it fully. So I now understand, Mr. and I don't. Just to be honest, when it's time for you or Ms. Ayers to make your argument, I would like for you to show me where that question is discussed or raised in the complaint, and you might just take a look at it while you're waiting, because I'm going to give you plenty of time to talk about it. But Mr. Martin, go ahead.
Justice, thank you, Justice. Justice, I orally, verbally incorporate my pleadings into my argument, Justice, if I miss something. But Justice, I also want to say that the city council, and I got Councilman Ashby Foote here, and it is never the intention of the council of the city of Jackson and as their independent special counsel to promote nor push any business. That's not I don't side with it. I just side with what's the law and what equitably should happen. If Richards gets it, fine. If Waste gets it, fine. The council has a vote, and my position as independent special counsel is that their vote matters. Justice, now on number 2 of your question, the second question was whether and under what circumstances the city council may contract to provide solid waste disposal services, if any. And Judge, it's my stance and the stance of the council is that it did. It may and it did. When the mayor fails to act, the council may act, Judge, and I direct the court to 2007 WL 4192044. That's the Office of the Attorney General, an AG opinion 2 of Mr. Charles Lawrence Jr. Esquire, the city attorney, city of Hattiesburg, Mississippi, Judge, and it says that when you have failure to act, the council may. Number 3.
What Attorney General opinion is that? What number?
I'm sorry, Justice, forgive me. It is 2007 WL 4192044.
Do you know do you know the Attorney General opinion number? Is it on there?
Your Honor, this is Chase Bryan. I don't want to interrupt, but we attach that as an exhibit to one of our filings, and I'll send you an email that directs you to that and copy the counsel.
I probably have it in front of me. Can you just give me the number? I've got a whole lot of these.
I've got you. Let's see the numbers on here. Oh, 2007-00510.
Okay.
Justice, forgive me for not being on top of that. It's so many. I've read a million documents this week. Forgive me, I didn't have it ready.
I guess for the benefit of all of you who are going to argue what I find troubling is that the mayor's position, as I understand it from what I just heard, and in your position and the position of Waste Management and others, is that yes, we have a Section 1 and 2 of our Constitution, and yes, we have separation of powers, and yes, we have an article or Section 2 of our Constitution that prohibits one branch from encroaching on the powers granted to another branch, which is a little bit more powerful than the federal Constitution. It's pretty clear. And I hear the council, city council, promoting the position that we're the city council, we're the legislative branch, and we have the exclusive authority to legislate, and I agree with that. But then taking the position that yes, but nevertheless we can enter a contract. And I hear the mayor's side of it, that we are the executive and we have the exclusive right to enter into a contract, but under certain circumstances we don't need the council. We can approve it on our own, or through some method it can achieve approval and doesn't need council approval. I'm having a hard time understanding the law that allows this court to overlook the requirement that the mayor, the executive of the city, has the exclusive authority to negotiate and enter contracts as an executive function, and the city council has the exclusive authority to review those contracts and approve them or not under the procedures that are set forth in statute. And so maybe I want you to focus on that, and Mr. Martin, and let me know where it is in the law. I know what these Attorney General opinions say, and I have great respect for the Attorney General opinions, but they are not the law. The statutes are the law, and I don't see anywhere in a statute authority for the city council on its own to negotiate and enter and approve its own contract. And that's what I would like for you to point out to me.
Yes, sir. I have that AG opinion stating at the second page, and this is what I have, Judge. One, you're right, I defer to you. But with respect to the issue of the execution of a contract, the action may provide that in the absence of the signature of the mayor, the execution can be performed by the council itself or a designated member thereof on behalf of the municipality. That's what I have.
No, I've read that opinion, and I know exactly what you have there. I get that. I've got Attorney General Opinion 2012-00013, where Mr. Tweezen, on behalf of the city of Jackson, asked the Attorney General similar questions, and it seems to me that his opinion is following the question I'm asking you. It seems to indicate that those are separate functions and have to be exercised by the executive and the legislative branches. And
yes, sir.
Are you able to point out in the statutes or in the Constitution some method by which the city council can negotiate and enter a contract without the involvement of the mayor's office?
Sir, everything that I've been able to find is that they need each other. They have delineated power. They have itemized power via the Mississippi State Constitution that delineates exactly what they're supposed to be doing, executive and legislative, i.e. mayoral and council, the council acting as a legislator. Okay.
All right, well, go ahead. I appreciate that, and I'm
yes,
sorry to interrupt you, but I know how hard
Absolutely.
it is when the judge interrupts you and you can't get back on where you were, so go ahead.
No problem, Justice. Number 3, it goes into city legal and adopting minutes. Judge, I have the clerk of the council present. The clerk of the council is Mrs. Mosley Jordan. She's been the clerk of the council for some time now. In her affidavit to the court and to the parties, she has stated that the city of Jackson's process for publishing minutes is minutes. Council meetings occur. Those council meetings are videotaped by PED. That's their IT department. IT centrally transcribes those. They get them back to council clerk. The council clerk forwards them on to city legal. City legal checks, verifies. Then they go to municipal court. I'm sorry, the municipal clerk. Then municipal clerk gets them to the mayor for the mayor's signature, and then they actually become minutes. It's my understanding that that process had been changed per this affidavit. The affidavit reads, on or about December the 7th, 2021, there was an order introduced to the City Council of Jackson to approve all regular, special, and zoning minutes by the council. The item was adopted by the Council of the City of Jackson on December 21, 2021, and published by the municipal clerk on February the 10th, 2022. On January the 25th, it's our understanding that the email from that's that on that. Then number 5 is the item I'm reading from. The ordinance was introduced to the City Council of Jackson because essentially of the refusal of the city mayor of the City of Jackson, Antar Chukway Lumumba, to sign and approve the minutes as they were rendered on August the 19th, 2021. And that's important, Judge. It's my understanding that plaintiff has promulgated an issue in circuit court, or just an issue period, that the minutes are not there, the minutes have not been published and approved. Or you can't argue, estoppel is our argument, but you can't argue, hey, there are no minutes, there are no regular minutes, when everybody understands the process, protocols, and procedures of approving minutes of the City of Jackson. And that approval process has been done for the past umpteen years forward until the December 7, 2021 meeting, Justice.
All right, here's the concern that I have about that issue. And I welcome anybody who argues tonight to help me understand it better. But my concern is, and we had issues similar to this come up often on the Supreme Court, even with the legislature. And with respect to procedures, how things move through the process, I've never understood it to be the court's prerogative or right to involve itself in procedures that are adopted by public bodies, even the legislature. The problem comes in when there's a statute that has a red line. And where there's a red line in statute, the procedures by which you achieve what the statute requires, that's one thing. But what the statute requires is another. And here's what I'm thinking, and Mr. Martin, you can correct me or help me understand where I'm wrong. Section 21-1533 says that the minutes of the municipality, those minutes that you're talking about, and I know they were sent to the mayor for approval and they went through the process through the clerk and all the rest of that, but in the final analysis, this statute requires them to be approved by a majority of all of the members of the city council or the mayor, if there's an ordinance that allows the mayor to do the approval. And it has a time limit, sort of a statute of limitations. It has to either be at the next regular meeting or within 30 days of the meeting. And so the argument that I've read, and the one that concerns me, is to discover what ordinance meets that test. What ordinance was approved by either the mayor or a majority of the council members at the next regular meeting or within 30 days of the meeting.
Yes, Justice, your understanding is my understanding with a couple caveats. My understanding that is as of Tuesday of this week, all of March's minutes, February and March's minutes were approved by the council by majority vote. And I'm getting that directly from Council Clerk 1 Judge, also Judge 2, Mississippi AG Opinion Warren, November the 16th. Chase may be able to get the number. I have the number, Judge. 2005 WL 1994231. It's 2005 WL 1994234.
That's a Westlaw. That's a Westlaw number. Do you have the AG opinion number?
Chase, did you have it, or Judge Gibbs, did you have it?
I do. It's 2005-0385.
Got it. Okay. Go ahead, Mark. Go ahead.
Yes, sir. Man, please, Court Justice. It does say that about the statute does require the time, the limits, but quote, this office is recognized that approval of the minutes outside the statutory prescribed time does not operate to invalidate any actions documented in those minutes. And so because, and again, AG, and I believe it was Mike Moore or the fellow before him, but that the office, what we have here is an issue of majority rule and getting back to the democratic principles of regular order and let the votes count. The council does not care if any garbage company, the council's job as legislative body for the city is to investigate, to get its citizenry a quality product and a quality service rendered. Whoever's going to do that, the council is okay with, but the process requires majority vote. That never happened, Judge. I tender.
Does the council take the position, and I hear what you're saying about the circular feature here, but does the council take the position that regardless of what the mayor may or may not have done, the council itself could have approved these minutes?
Judge, it's my understanding from talking to the council clerk that the procedure for approval of minutes was in place before she got there, and it was ongoing and up until the December 7, 2021, when that ordinance was introduced to modify to get the council in line with state statute, and having the council only approve its minutes was when this happened, is what I believe that the majority of the council will state, that they were following previous protocol and procedure.
I'm satisfied that's exactly what they were doing. My only question is whether the council takes the position that because that procedure was in place, they had no prerogative, they had no option to say, well, it looks like the mayor is not going to sign this and approve these minutes, so we're going to do it under Section 21-1533.
Judge, I'm independent. Justice, I'm independent special counsel. But I would have told them that the day that I first had been retained, but I'm only working now. And once I caught wind of it, I let them know that's not what's supposed to be happening. What's supposed to be happening is per state statute, and you don't need anyone to approve your minutes but you.
Okay, good enough. Thank you. Let me go back to Ms. Perkins and ask if Ms. Ayers has become available yet. You're on mute, Ms. Perkins.
No, sir, she hasn't, but I think that I may be able to. If not, I'll tell you, we take a recess.
Yeah.
Somebody was calling me, but
okay.
May I proceed, or do you have a specific question?
No, I want you to feel free to address the questions that I've asked, and you've heard what my concerns are. So, and just to zero back in, I've read in the submissions from the mayor's office the same thing, that we do have this separation of powers, and there is an executive branch, and it has exclusive authority to do certain things. But then based on what you said a few minutes ago, it seems the mayor may want to say, yeah, but under certain circumstances, the mayor can enter a contract without any involvement of the council. And that's kind of what I want you to help me understand, how not just Mayor Lumumba, any mayor,
Okay.
under the law as it exists in this state, you tell me what circumstances allow a mayor to negotiate, sign a contract, and it become a valid contract without involvement of the council, and what law supports that position. And I'm asking you that, and I'm also sort of asking Mr. Walker, who represents Richards. I know he takes that position as well, and so he can supplement anything that you miss, which is doubtful. But if you do, he can supplement it. But that's a real question in my mind as to what law would allow that to be done.
All right. If I may, Your Honor, I think when you asked me the question in the middle of Mr. Martin's argument, you referenced the brief that we filed, and where the court noted that in there we said that when the mayor entered into the contract, that the contract had to be presented to the city council for approval.
Yes.
I think, okay, and that's on, and when I'm referencing, and this is document 1 of our emergency complaint for declaratory judgment, and it starts on page 15 at the bottom.
I'm looking right at it.
Okay, all right. It starts at step 3, option 1. And what we were saying in that, Your Honor, when we were giving the analysis and the application of Mississippi law, is that the mayor has authority to negotiate and execute a contract. And that contract does have to be presented to the city council, but it doesn't have to be presented to the city council for authority to ratify the negotiation and execution of it. The city council, which we have established, and the court is well aware, is the legislative body. They control the purse strings. The city council's job is to get that contract, see if it falls within the budget, and when it's presented for payment, the contract, the person in the contract, the vendor, can't be approved, can't be paid unless that contract is approved by the city council. Okay. So I wanted to make that clear right there. So
that's how I read. Yeah, that's how I read. That's how I read the position in the complaint, and how I had understood the position of the mayor. And as a matter of fact, it was one of the issues argued to me as a basis to allow Richards to intervene, because it was supposed to be the difference in the positions of Richards and the mayor's office. So I was a little bit surprised when you said, but that clarification helps me understand, and I appreciate that. I get it. So go ahead.
Yes, sir. And I want to address something else too, opposing counsel said. And I too have read pages and pages and pages of documents in this case since it started. And, there's a lot of reference that the mayor didn't have authority to declare an emergency. And then opposing counsel just said that there was no emergency under the statute that fit to the statutory definition. Well, we take issue with that. The same emergency existed in February when he declared an emergency that existed back in, I believe it was September or October, when we wound up in court as a defendant, okay, because the mayor had declared an emergency at that time. And at that time, Waste Management was given a 6-month contract based on an emergency. So it's absurd to say 6 months down the line, when the mayor declared an emergency, that no emergency exists, and no one has the authority to declare, well, I shouldn't say no one. The mayor does, in fact, have the authority to declare an emergency, and he did, and an emergency exists. And there are several provisions under the statute that would fit for an emergency when you're talking about waste collection that needs to be picked up. So our position is, Your Honor, an emergency existed. The mayor entered into this contract, negotiated, entered into this contract with Richards. And I want to make sure that it's clear too, that Richards was the lowest bidder and that Richards got more than 2 votes. I believe that the number of votes was incorrectly recited in the record. Now, when we filed this initial complaint for declaratory judgment, we didn't file it with the intention of arguing whether the contract should be awarded to Richards, whether it should be awarded to Waste Management. And then, we have this waste disposal that I had never heard of before, who's now in this case. But there was another vendor or two out there as well. We filed this complaint for declaratory judgment because there appeared to have been so much confusion on the legal authority between the executive office, which is the mayor's office, and the legislative office, which is the city council. And we asked for 3 things. We asked for this court to declare that the city council has no authority. And this is going to answer the court's question too, that you asked to attorney for the city council, that we wanted the court to declare that the city council has no authority to negotiate and or execute a contract for the collection of residential solid waste, absent the exceptions that are listed in Mississippi Code 21-819. That's number 1. Number 2, we want the court to declare that the city council has no authority to amend the mayor's order declaring a local emergency. And instead, after the mayor declares a local emergency, that the city council is required to either approve it or disapprove the proclamation. And the next thing we want the court to declare is that the mayor has the authority to find independent contractors or vendors who can provide emergency services and then present that contract to the city council for the same reasons that I just said before. We had limited specific requests for relief. Now, anything about the particulars of the contract with the negotiations with Richards or any contract like that, that was done with the office of the city council. And, Your Honor, that's just our position. And we have cited all of the authority, and we would like a declaration on these 3 simple requests.
Right. And if the court ended up agreeing with you on everything that you have urged in your complaint, the result of that would be that there is no contract and that somebody needs to do something to get a contract in place. But because there has been no contract that the mayor has negotiated and executed that has been approved by the council, there's no contract in place. Am I misreading what you're asking the court to do?
Yes, you are. You're misreading and you're misunderstanding it too.
Okay.
Our position is that the mayor has already entered into and negotiated a contract with Richards Disposal. Okay. That does not have to be necessarily approved by the city council now. Richards Disposal has not, to my understanding, presented any kind of bill for payment. It has not been submitted to the city council. That contract eventually is going to have to be submitted to the city council for approval. But the question, the question as to whether that contract is valid and enforceable, the answer would be yes. However, I want to remind this court, and we've said it several times in our pleadings, we're not asking in our complaint for declaratory judgment about a specific vendor. Okay, just like opposing counsel said that the council, they didn't really care what person got the contract. We want the framework and a good understanding between these parties and a declaration from the court as to the rights and the legal authority of the office of the mayor, and then the same thing from the as to the office of the city council. And we believe a judicial finding of those provisions will probably help resolve whatever issues that these two have down the road. So that's the mayor's position, Your Honor.
We may be mincing words here, but what I hear you saying, and you can call it approval or whatever other term you like, but the bottom line is that whatever the mayor has done, call it approval or execution or entered the contract or whatever, Richards is not going to get paid unless the council approves it. You agree with that?
I think that would be a question that's best for the city attorney, but I think that anybody who would get paid from the city would have to be approved by the city council. I think that's the way that it works. Okay.
Okay.
So.
All right.
I think that's the way that it works. And okay.
Okay. And so, Ms. Martin, Katoria Martin, what do you have to add on behalf of the city of Jackson insofar as it has a position different from the mayor's office? Or otherwise, I'll hear you.
Your Honor, Tori Martin on behalf of the city of Jackson, if it pleases the court, I think we would just offer some clarification about procedure.
Okay.
And so the clarification that this office would offer is pursuant to Mississippi Code 3315-17, the mayor declared an emergency on September 30th, 2021, and the mayor also declared an emergency on February 17, 2022. Both of those emergencies were declared pursuant to the exact same statute, 3315-17. The procedure in September was the mayor declared the emergency, the mayor entered into and executed an agreement with the vendor, and that vendor started performing work on October 1st. That agreement did not go to the city council for ratification until October 26th. And that vendor was providing services to the city of Jackson for 26 days before the city council ever ratified an agreement with that vendor. In this instance, the clarity that we would offer is the mayor declared an emergency on February 17, 2022. The mayor actually executed an agreement with the vendor right after that emergency was declared. What this office has, our research shows, is based on the statute, so 3315-17, and the Bolivar County case that we offered in our brief. So Bolivar County v. Walmart stores. Our position was that the contract itself does not require ratification. However, the payment does require that the city council approve it. And so we offered an AG opinion, and I know you requested earlier the AG opinion numbers. The number for the AG opinion I'm referencing is 2002-0393. And it's an AG opinion from 2002. And in that opinion, the AG gives the opinion that in an emergency situation, the statute, the emergency management law, which is 3315-17, is a controlling statute in times of emergency. That opinion also states that counties shall have the power to enter into contracts and incur obligations necessary to combat such disaster. The last thing that opinion states is, the opinion of this office that a county may enter into a contract without regard to purchasing laws, provided the contract is entered into while there is a declaration of emergency properly in effect. Under the facts presented, it's our opinion your county can pay the amount in question. So pay the amount in question. We would say that that's referencing your claims docket. If the Board of Supervisors finds, consistent with fact, a declaration of emergency was in effect at the time the contract was entered into, so that's number one. The declaration of emergency was declared prior to the agreement being executed. Number two, that the quantity of work claimed was actually performed. We would say that that's in line with the procedure that we've offered that occurred in September and that we anticipate will occur in April. And number 3, that the work was necessary to combat such disaster. So what we would offer for clarification is that there is still time for the agreement that was executed by the mayor. We do believe it's a legally binding agreement. However, we also believe that under the emergency management law, there is still time for that agreement to go back to the city council. And the claims docket statute states that we have 45 days before we will have to render payment to that vendor. In September, it took 26 days for the city council to render an opinion on that contract and payment for that contract. In April, we don't know if it will take the city council 45 days, but what we will offer for clarification is that the mayor actually had submitted this contract. The Richards disposal contract was actually submitted to the city council for ratification on February 24th. It was submitted to the city council. When Waste Management filed suit on February 25th in the circuit court, our office advised the mayor to withdraw that action at that time from the city council to wait on that litigation to be resolved, because it was always our opinion that there was time. There was still time for the city council to ratify that agreement. So the last thing we will offer in terms of clarity is, I think previously when Your Honor, when we met on March 21st, Your Honor stated that if you sided with the city council, that would result in an agreement being awarded to Waste Management. And if you sided with the mayor, that would result in an agreement being awarded to Richards Disposal. What our office would say is, based on the procedure as we understand it, if Your Honor sides with the city council, that means that this agreement most definitely must be ratified by the city council. And we would say that we have 45 days from April 1st, or the mayor has 45 days from April 1st to present this contract to the city council for ratification before payment will be due. Because payment will be due within 45 days of them commencing the service.
And what if the city council doesn't ratify it?
If the city council does not ratify, we think it's a factual determination for the city council to make based on the AG opinion that I referenced. And there are 3 things for them to determine: whether there was a declaration of emergency was in effect at the time the contract was entered into, whether the quantity of work claimed was actually performed. So they at that time will make a factual determination of whether Richards Disposal has actually collected garbage as they were supposed to pursuant to their contractual agreement, and whether the work was necessary to combat such disaster. So whether if Richards Disposal did not collect garbage, whether that would have resulted in an emergency situation in the city of Jackson. That's the factual determination that we think the city council would be left with making upon determining whether they should ratify the payment or not.
Okay.
Justice, can I get a second?
Sure, certainly.
Justice, I'm sitting in my office with Councilman Foote, the clerk. The case, I never take it an issue to argue with any Mrs. Martins because I'm married to one. So, but forgive me, Mrs. Martin. They bring up Judge Bolivar County. Apples to bananas or oranges to pineapples. They aren't the same thing. The Bolivar case, Judge, was an ice storm. In this jurisdiction, the total amount in Bolivar, Judge, was $19,000. The total amount in this contract is $9.6 million. Judge, the issues in Bolivar aren't ours. 1, then 2. Putting the citizens on the hook for a new contractor without the council's innuendo, the council's acquiescence, and say, okay, look, I approve of this contract. Now pay this guy, pay this company this money. Judge, that smacks of insincerity. The actual process of a bill becoming a law, how to hire a contractor, even an emergency, that's contra to everything that we're doing here. These aren't the same things. Bolivar is not Lumumba versus the council. Ice storm, true emergency, ice everywhere, nothing working, lights off, no running water, a $19,000 bill versus the ending of COVID, Judge. Vaccine everywhere. That's the only emergency I can see in the city of Jackson. And you have that. I tend to judge. Thank you.
Okay. All right. Yeah. Let me go ahead and hear from Mr. Bryan on behalf of Waste Management.
Your Honor, I need to back up and have a little history lesson of this case. There was an RFP that was issued back in March of 2021. In August, the mayor selected a vendor called FCC for a 6-year contract, which was voted down twice. The mayor then turned on August 26th and 27th to work with Waste Management under the guise of negotiating, and the mayor said he would not agree to a 6-year contract under the RFP, but he would agree to a 1-year deal, which was not part of the RFP, and Waste Management did not do that. And so what the court has to understand is there has never been an emergency that fits the statute declared by the mayor. September 17th, because he didn't get his way with the vendor, he declared an emergency and tried to negotiate with a different vendor, FCC. At that time, counsel for the city council, Roy Campbell, filed a lawsuit seeking a declaration that the council had the authority to enter into a contract. And so if you look at the notice of hearing I sent around 6 months ago today, on September 30th in the Chancery Courthouse, we made an agreement with the mayor for Waste Management to continue providing service for 6 months for the RFP process to start up again. So at that time, the city council and the mayor were in agreement that Waste Management should continue for 6 months. And so to compare that emergency declaration and the execution of that contract with this situation is comparing apples and oranges, except that the mayor used the emergency declaration then as he's doing it now to manipulate the RFP process. If you look at the cases that deal with this, it does require a disaster or some sort of emergency. You can look back at even old Supreme Court cases that talk about an emergency. There's one from the 30s called Atala versus Mississippi Tractor Equipment Company, and they look at what's an emergency. An emergency is an unforeseen occurrence or combination of circumstances which calls for immediate action or remedy. This is not such an emergency. Here, what's happened is, again, the mayor has not gotten to select his preferred vendor, and so he's again declared an emergency. Back in February, with over 6 weeks left in the Waste Management contract, he declared an emergency. The next day, on February 18th, Waste Management offered to extend the contract 30 days to allow the RFP process to continue. At no time did the mayor negotiate with Waste Management or any other proposer under the RFP. So what we have here is not an emergency. We have a mayor not getting his way and manipulating the process. And so you asked earlier, what case law is there to deal with this situation? There's not any, because what's supposed to happen is the mayor's supposed to recommend a contract and the council's supposed to approve it. But here that's not happening, and it's not going to happen because they can't seem to agree. And so the question is, what do you do? The first question is easy to answer. There is no valid emergency contract entered into by the mayor. His declaration of emergency does not comply with the statutes or the case law that deals with that.
Let me stop you because
yes, sir.
I have two thoughts and concerns about that. Number one, so what if there were an emergency? I'm still stuck with a contract that's not been approved by the council. So I don't know why the argument is so heated tonight about whether there was or wasn't an emergency. I still don't have a contract that was proposed by the executive branch and approved by the legislative. So suppose there was an emergency. So what?
If there was an actual emergency like an ice storm like there was in the Bolivar County case, you can actually go out and buy things like flashlights and batteries and candles and shovels and axes, which they did do in that case. And in that circumstance, you can do it. But you've got to have an emergency to enter into a contract. I mean,
All right,
they're saying that the mayor can enter into a 1-year, $9.6 million contract by saying emergency, like it's a magic word and it changes the law.
No, you're missing my question.
Okay.
I'm asking you, if there was an emergency, can the mayor enter into this Richards contract?
If there was an emergency for
Yes.
a year, I don't think so. I think that there's got to be some common sense that comes into play, and you can enter into a contract while the emergency persists, but there's not going to even be an emergency for a year. So I don't think that he can do that.
You're taking the position that if there did exist an emergency, the mayor can enter into a contract without approval of the council for some period of time.
Well, he has to go in. He has to go in and have the state of emergency approved.
Hold on. You're being a good lawyer here. Step one.
Yes,
are you taking the position that if there was an emergency, the mayor could enter into some contract without the approval of the council?
If a tornado came through downtown this afternoon,
as they say in the courtroom, that's a yes or no question.
Oh, I cannot explain. Under certain circumstances, of course, the mayor can enter into a contract if there's a real emergency. Absolutely.
And what is the legal authority for him to do that?
The statute provides for it.
Show it to me.
The 33, the one we've been talking about the whole time, 33-15-17, I believe is the number of the statute. Let me make sure, but that authorizes him to do that under certain circumstances. 33-15-17 is the emergency management statute.
Which subsection? I have it in front of me.
Oh, let's see. Part B, it says they shall have the power to enter contracts to combat a disaster. So I think you have to look at what's a disaster. But if there's a true disaster and a real emergency, they can enter into a contract.
As I read that statutory provision, it says in carrying out the provisions of this article, each county and municipality. It doesn't say the mayor. It says each county and municipality acting in jointly or more counties acting jointly, etc., in which any disaster, as described in Section 33-15-5 occurs, shall have the power. And nobody's disputing that the municipality has the power to enter into a contract. And I think, and I'll just give you the benefit of what I'm thinking, I think the purpose of all of this is to say you can skip the RFP process. You don't have to go through the formalities of the RFP process to get a contract in place quickly, but that doesn't give you the right to bypass the obligation of the mayor to propose and the council to approve. Now that again, all I'm trying to do is give you a chance to show me where I'm misreading this, because that's what it says. I don't see any authority anywhere for the mayor to enter into a contract without approval or ratification of the council. And if y'all can show it to me, I'm happy to read it, but I don't see it.
I think that you're right. I think everybody envisions a situation where if there is a real disaster like the Bolivar County case, that the council wouldn't, in bad faith, withhold consent to that. And I think people would say when there's a real disaster, the mayor has to have the ability to get that process started and get tarps on roofs or wherever the case might be. But I think you're right that it does not single out the mayor and give him authority alone.
It seems to me to be a function of when the garbage starts piling up and the pressure starts to mount on the council and the mayor, they look at this statute in a sort of a different light and determine what do we have to do to get this solved. But it doesn't seem to me to provide either branch of government with the exclusive authority to solve the emergency. It just doesn't seem to me to do that. And I'm trying. I've looked. I promise all of you, I've looked since this thing got filed and I got assigned to this case. I've looked everywhere I know, from the Constitution to all the statutes, Attorney General opinions, and I just don't see binding authority for that to happen. And
Justice,
so,
your understanding of the law is the council's.
Pardon me?
Your understanding of the law is the official stance of the council. Yes.
And here's the other thing, and I want all of you to hear me on this. The other thing is, if part of what we have here is a dispute about whether or not there was an emergency. I can't decide that in this forum under these circumstances. That's a factual question. It requires a trial. I don't know. The mayor takes the position that it was an exigent circumstance. I'm not trying to speak for the mayor. This is how I understand the pleadings. The mayor seems to take the position that because the waste management contract is going to expire in a couple of days, and there is no valid enforceable contract for the collection of solid waste, that the health problems and other types of problems associated with that create an emergency. Mr. Bryan, I don't know if it does or not. I don't know the extent to which garbage piled up is dangerous or not dangerous, or how long it has to be, whether it's a few days or a month. There are a lot of facts that I would have to hear in order to conclude the mayor was correct in declaring an emergency. Maybe he was, and maybe he wasn't. I don't know. As I read the mayor's complaint, I don't view that as something I have to decide here. If I do, then we got a problem, because we're not going to get this resolved in time to know whether or not Richard's contract is in place or it's not in place, or Waste Management's contract is in place or it's not. We're just not going to do that.
Your Honor.
So hold on just a second. Let me let Mr. Bryan conclude with anything else he wants to add.
I think you zeroed in on the questions that I had about it, or the thoughts that I had on it. The only you asked what authority would there be for the council to act, and I agree with you that the AG opinion is not binding, but like you, I and others have looked high and low, and I don't think there is a clean answer to the question of what do you do when they're at loggerheads like this and can't agree. I do think that Hattiesburg AG opinion provides some guidance where that mayor, like the mayor here said, only I can negotiate a contract. And when the mayor abdicates his responsibility to act, at that point the council can, as a governing authority, execute a contract. And I think you could apply some equitable principles like estoppel to allow them to do that. But from a pure legal statutory standpoint, there's no authority to do that.
Well, it's not like the citizens or the council or others are without a legal remedy. There's mandamus. There are lawsuits that can be filed that force the city to, or the mayor or the council or anybody else, a judge, me, to do our jobs. So it's not like, well, we've got the mayor who won't agree with the council and the council won't agree with the mayor, so we're not going to have a garbage contract. It's not like that's the way it is. There are remedies, but that doesn't change the fact that what I'm looking at from a statutory and constitutional standpoint is a situation where I need to find a contract that is proposed by the mayor, negotiated by the mayor, and approved or agreed by the council. And I'm actually not even sure I need to find that in this case, because when I read the mayor's complaint, literally what the mayor has filed, I'm not sure there's anything in there I disagree with. I'm not sure there's anything in there you disagree with. The mayor's complaint simply asks me to agree that a whole list of statutes are in place, and I do, they are, and they say what they say, and then it just asks me to declare in a declaratory judgment action. If you look at exactly what I'm being asked to declare, it's not complicated. It is that pursuant to 33-15-17D, and tell me, by the way, Mr. Bryan, you tell me, or Mr. Martin, on behalf of the council or any of the rest of you, you can be thinking about this question. Tell me which, and make a note, which of these things do you disagree with? The mayor proclaims a local emergency as defined by Mississippi Code 33-15-5. Exists in the municipality. That's step one. The mayor's asking me to proclaim that. declare that as the law. Well, I read the statute, and that's exactly what it says. So I don't know how I could not declare that A is correct. B, pursuant to Mississippi Code 3315-17B, and C, the mayor's proclamation may include a plan to combat the disaster that necessitated the proclamation of the local emergency. I don't think anybody disagrees with that. C, if the mayor's proclamation includes, the way this thing's written, an intent to enter into a contract with an independent contractor for the purpose of collecting residential solid waste on an emergency basis, then the mayor would need to present the proposed contract to the city council for approval. Now, that's where I've been asking all night. That's what the mayor's asking me to declare. I understand that to be correct, but I've been trying to find out if anyone can show me where that's legally incorrect. And then it says the mayor may call a special meeting pursuant to Section 262D of the Code of Ordinance of the City of Jackson. I think everybody agrees that's true. And then it lists the ordinances. I guess I'm just trying to. I'm perplexed and concerned because we only have a day or two. And it looks to me like what I'm being asked to do here is probably going, and I want to hear from Richards, because Mr. Walker, because they may have a different perspective, but as it stands so far, it looks to me like what all this results in is like a car wreck lawsuit. I'm saying to the plaintiff and the defendant, y'all need to get together and work this out, because there needs to be a contract with somebody so that somebody can pick up the trash. But I may be wrong about that, because I know Richards and Mr. Walker, on behalf of Richards, has taken the strong position that the contract the mayor signed is enforceable and doesn't need council approval. So, Mr. Bryan, do you have anything further, or can I get to Mr. Walker? I'm sorry, I'm going to hear first from Mr. Gibbs, but who I'm always happy to hear from. But anything further from you?
Not at this time, Your Honor.
All right, Mr. Gibbs, let me hear from you. I know that your interests are sort of tied to waste management, but you may have a different perspective, and I'll disclose to all of the lawyers here that Mr. Gibbs and I taught law school together back in the day, and so we're friends, and I respect his legal opinion. So, Mr. Gibbs, tell me what you have to add to what Mr. Bryan has said.
Judge, I learned a long time ago, when a judge directs you to certain questions, you ought to try to answer those questions. The question that you posed about the emergency contract, I don't want to argue with it. I don't believe there's an emergency, but the fact is the mayor did declare one. But usually an emergency only lasts for a few days, maybe a month. Here we have an emergency contract for 1 year. Even if there is an emergency, I don't believe there's any law that allows the contract to last past the emergency. If there is an emergency, the emergency can be cured with further negotiation per the RFP process. And that's one of the problems that I have. The city talked about all of the work that they did for an RFP to go forth this time, all of the time, effort that went into it. And yet, when the mayor did not get his preferred vendor voted for by the city council, rather than completing the RFP process, he declared a local emergency. I think that's a violation of the RFP, which is something we hadn't talked about today. You have an RFP in place that has not been completed. One vendor has been voted down, and the process is to go to your next vendor. That happened back in September of 2021. For some reason, it didn't happen this time. And again, to me, that seemed to be a violation of the separation of powers, but the mayor doesn't want to comply with his own RFP and instead issue an emergency to go around it. And if the emergency is indeed valid, I don't believe that emergency can last until the emergency is over with. And that can take place very easily by the mayor negotiating with the second vendor. Thank you, Judge.
Do you, Mr. Gibbs, do you view it as my responsibility in this case to decide whether there was or wasn't an emergency?
Well, initially I did, because I don't think you need a fact-intensive decision in this case, because as Mr. Bryan said, the case law on emergency is pretty clear. It has to be some kind of storm, hurricane, tornado.
My question to you is, though, based on the issues before me, and I don't mean this the way it sounds, but based on the issues before me, what difference does it make whether there was an emergency? I still don't have a contract that's been proposed by the mayor and approved by the council. So whether there was or there wasn't. Now, you bring up an interesting question, which is, if however it gets decided there was an emergency, then you do have an RFP process that has to be utilized. And if that's true, the question becomes whether that process can be complied with timely in order to avoid no collection of solid waste in the city of Jackson for some period of time, which very well may be an emergency. I don't know. But you bring up an interesting point. But as this case exists before me now, I'm having trouble. I'm having trouble understanding why it matters as to whether or not there was an emergency, because whether there was or there wasn't, I just don't have a contract that's been approved and put in place and is enforceable pursuant to the requirements of statute and the separation of powers. I just don't see that at this point. I'm going to certainly listen carefully to Mr. Walker, who's a great lawyer, and find out what he has to say. And he may persuade me otherwise, but as it stands right now, I don't. So do you see my point, Mr. Gibbs? I hear everybody talking about, there really wasn't an emergency, and the mayor did this and the mayor did that, and maybe he did, maybe he didn't, but just don't see it as an issue that affects my responding to the questions the mayor has asked in his complaint. And
Judge, I understand exactly what you're saying, and that's the reason I wanted to preface it by answering your question. And I do agree that you don't have a contract that has been approved, so we don't have a contract here. Unfortunately, the mayor declared the emergency 6 weeks before the contract expired. There was clearly plenty of time in that 6-week period to negotiate with the other vendors who responded to the RFP, and the mayor refused to do that. So ultimately, we are here, I believe, because the RFP process was not complied with. Now, we are at the last hour. We don't have a contract. If something is not done before midnight tomorrow, garbage may not be picked up in Jackson on Friday. I think that's the reason that both branches of government went to court back in September of last year, because we were in the same situation, and the court did exactly what you said. Parties ought to get together and find some solution, because right now there is no contract. The emergency contract that the mayor entered into has not been approved by the council, so there is no contract. And unless something is resolved tonight, I don't see how anyone on Friday morning can pick up garbage in Jackson.
All right. Well, thank you, Mr. Gibbs. Let me hear from you, Mr. Walker.
Your Honor.
Yes.
Yes. Before we go to Mr. Walker, may I just briefly respond, or do I need to wait until it comes back my turn?
Time is time. I'll give you the choice.
Okay.
It'd probably be better if you respond now, so Mr. Walker can also respond to your response. So go ahead.
Okay. I just want to make sure that the position of the mayor is clear, and I want to reiterate that there is a valid and legally binding contract with Richard's Disposal. The city council has not approved it because the contract is not right for consideration by the city council at this point. So, I want to make sure that, Mr. Gibbs, saying there is no valid contract and we don't know what's going to happen on April the 1st. Well, we do know what's going to happen on April the 1st, and it's going to happen in accordance with the contract that the mayor, with complete an absolute authority had that negotiated and executed, that's what's going to happen. So I just want to make sure that our position is clear. And another thing I want to bring up too, I may not have heard it correctly, but under section, the mayor does have authority to declare a local emergency. In that section, it gives the mayor, let's see if I can find it. It started back raining downtown where I am, so I may not have heard it. But under, let's see, I think it's section D.
Section D.
3315D, it says that the mayor can proclaim the existence of a local emergency. And it's the mayor who has declared the local emergency. Just because these people who want to continue this contract with the city of Jackson keep saying that there was no emergency, that's not their decision to make. And I agree with the court. If a determination needs to be made whether an emergency exists, then that determination needs to be made after, upon the filing of the appropriate pleading with this court, making it an issue, and only after a full evidentiary hearing is had. So,
but I'm looking at section D of that statute, 3315-17. It just simply doesn't say that. It says the mayor certainly has the authority to declare the emergency, but it certainly does not say he has the authority to enter into a contract without council approval. I don't see that in there.
I wasn't offering it for that. I was offering
Okay.
Yes, I was offering it for that reason. Yes.
Okay.
Yeah.
All right. Mr. Walker.
Your Honor, even a greater lawyer than me, Ms. Green, Attorney Green, will be responding to the arguments that have been made so far.
All right. Ms. Green.
Good afternoon. Good evening, Your Honor.
Good evening. Ms. Green, if I may be presumptuous, just because I'm keeping notes here, tell me your first name.
Gloria Green.
Gloria Green. Thank you, ma'am. Go ahead.
What I want to do is that in light of the fact that much has been said about the authority of the mayor to declare an emergency in the RFP, I'd like to be able to make a few comments about that first.
Okay. All right.
Okay. Now, Counsel for the City Council and Waste Management, Waste Disposal, they keep talking about an emergency, but under section 3315-7, a man-made conditions can also create an emergency.
Yes.
And we submit that that is what happened in this case. And now I'm going to go back to the RFP. Everybody keeps talking about the RFP process, but we submit that the RFP process was not followed by the city council. And that's what created the need for the emergency. Secondly, Waste Management says that an emergency was not necessary, I guess, for its contract, but that's not true, because under section 31-713R, a garbage collection, solid waste collection contract can only be entered pursuant to that section, and that section says an RFP. And once that RFP is done, and the successful proposal is selected, and a contract is, the statute says that the contract shall be awarded to that person. And that's what has happened in here. The contract has not been awarded to that entity. In Preferred Transport Company, LLC versus Claiborne County Board of Supervisors. In looking at this statute, the Supreme Court said that when interpreting the construction of a statute, the term shall renders the action mandatory. Therefore, when Richards was selected as the most qualified proposal, the contract should have gone to him in the first place. But because the council did not do so, that created the emergency. Now, we're talking about whether or not the council had to approve the contract. The council had to approve the contract under the RFP. But what the Preferred Transportation Company said is that if the council did not approve the contract or withheld approval of the contract based on factors other than the RFP, Their decision was arbitrary and capricious, without substantial justification, and illegal. And that's what has happened in this case, and that's why the mayor has been placed in the position that he has been placed in. In that case, in the preferred transport case, what the council did is say that we want to give the RFP to somebody who meets our personal qualifications, to somebody who is local and would provide services for elderly customers and provide employment for local citizens. That's the same thing happened here. The council decided that if it's not broke, why fix it? The council decided that three council persons, I think, said that, and then one said, if it's working, why make a change? Well, you make a change because the law says so. And by the time that this RFP was entered in October 2021, Waste Management had gotten the maximum amount of the contract that it could have gotten under that present contract. That's why the RFP, that's why an emergency has to be declared. We submit too that the contract, emergency contract with Richards, did not have to be approved by the council for a couple of reasons. First of all, as mentioned by Attorney Martin, Katoria Martin, in her presentation, the contract with Waste Management, this emergency contract with Waste Management, was entered into on October 1st, 2021. It was not ratified by the council until October 26, 2021. So we've already entered into a contract without council approval, allegedly without council approval, because according to opinion written by you, Justice, the groundwork opinion, it says that unless the action of the council has been ratified, reflected in the minutes, the action is not legal. So it's a good thing that the contract does not have to be approved by the city council, because if it does, then we're operating right now under an emergency contract that is illegal and not binding, because the council has not approved the contract. Why the council has not approved the contract? Because it's not reflected in the minutes. Now, something has been said about the fact that the minutes have been written, but it doesn't matter. Under the statute, and I have a case, and the case is Alias versus City of Oxford.
Alias, give it to me.
Alias, ALIAS versus City of Oxford, 70 Southern 3D 1114. And what that case says, that if the minutes were not signed within the 10 days, now 30 days, they were not void, but under the saving clause of the statute would be valid from the time of signing. The time of signing, no matter what happens with the October 2021 minutes, won't happen until now. So if the signing is not effective to date back to the date of the meeting, then we've been operating under a contract that's not authorized by law. And according to section 3751, I think I have the right statute. Let me make sure I'm going to the statute that talks about payment by public bodies. According to section 31757(2), if the contract was not valid and entered into appropriately, then the council should not have been authorized in payment, because the statute says that you cannot authorize payment for a contract not authorized by law. And if the minutes were not adopted to approve this contract, the contract was not authorized by law. On the other hand, if our interpretation of the emergency management law is correct, then the contract did not have to be approved. And we submit that that is what happened, because that subsection D that Attorney Perkins referred you to only requires the council to approve or disapprove the continuing need for an emergency. That Bolivar County case goes right along with that. If it's an emergency under that, the regular procurement statutes do not apply. Separation of power is still there, because under separation of power, the council controls the purse. And we're not saying that the payments won't have to be approved by the council. We're saying that the contract was entered into by the mayor during a lawfully declared emergency. And at this point, the mayor is the only one who has a lawfully declared emergency, because no other action has been taken by the council that is legal and valid at this point. No minutes, no action.
Well, the statute 21-1533 Now, it is the statute that relates to the minutes and approval of the minutes, and it does say that that assuming, and it does assume that at some point the mayor or the council approves the minutes, votes to approve the minutes. It says that the minutes have the legal effect of being valid from and after the date of the meeting, meaning it does relate back, so long as they're approved. You're saying there's a different effect if it's an emergency contract?
What I'm saying, Your Honor, is that there's a condition precedent. In order for them to date back to the date of the meeting, the minutes would have had to be approved within that 30-day time frame.
Right. That's what I said. That's in that statute. Assuming that's true, they do relate back. But if it's not within that time period, if the minutes aren't approved within that 30-day time period required by the statute, then they're not approved at all.
Well, according to this case, they won't date back, but there's a saving clause that says that if they're approved today, then they will be effective today.
And you're saying that's in the
Alias versus City of Oxford case, and it's quoting a Crawley case. I don't really have the quote for that, but
that's all right. I'll look it up. I need to see that case. Okay, I appreciate that.
And again, we like to emphasize that Mr. Richard is able and ready to do that contract to carry out the emergency collection process on April 1st, 2022.
Yeah, the problem I have is that I don't know that the RFP process. Are you saying, Ms. Green, that the Richards contract is a product of the RFP process or a product of the emergency declaration?
I'm saying the Richards contract is a product of the emergency declaration, which was necessitated because of the council's refusal to comply with the statutory mandate of awarding the contract to the vendor under the RFP.
But you're not pushing me off into the world of RFPs.
No, Your Honor. What I was doing is because there had been much to say about the RFP process not being followed, and there not being an emergency. I wanted to put it back in real terms. The RFP was followed. The council just did not honor its responsibility.
Well, tell me or show me what your primary authority is for claiming that the mayor can enter into a binding contract without council approval.
I said, Your Honor, I'm only saying a binding contract without council approval during an emergency declared pursuant to Section 3315-17.
All right, well, just a minute, because I'm going to pull up 3315-17, and I'm going to ask you the same question I just asked a minute ago. What provision says that he can do that?
Because if you look at B,
I'm looking at B.
It says that the emergency powers is authorized without regard to time-consuming procedures and formalities prescribed by law pertaining to the performance of public work and the entering into public contracts and the incurring of liabilities. And I'm also saying that I'm also relying on the Bolivar County case.
For that to matter, the requirement that a contract be proposed by the mayor in the executive branch and approved by the council would have to be a formality rather than substantive law, and I'm not sure I see that. In other words, I do understand that in times of an emergency, the legislature has said you don't have to go through the RFP process. But number one, I don't see that they've actually said you don't have to have it approved by the council. And number two, I'm not sure they can. I'm not sure that a statute can override the Constitution, which is where the separation of powers comes from. Now, number three, I'm not sure that's before me, but what's before me are the questions raised in the mayor's complaint. and those are what I have to address, and none of those ask me to address whether or not Richard's contract is valid because of the emergency. It just asks me to declare what the law provides, and so, I mean, I see what you're saying, and I'm definitely going to read this case, but
John, I would refer you again to the Bolivar County case.
right, I'm going to read it tonight, and I appreciate that.
And I also would like to add is that we're not saying that separation of power should not be honored. The separation of power says that the council has control of the purse. We're not taking away the control of the purse. We're just saying in an emergency, the mayor can execute the contract. The council still has its separate function to approve payment. And I would also may I add one other thing.
Wait a minute. Hold on. Before you add one more, let's stay with that provision, because that's been said 3 or 4 times tonight, and I don't understand the difference. If the mayor enters into a contract and the council doesn't approve the payment, what happens?
Well, if they don't pay, if the council doesn't make the payment, then a court of law would have to determine what is the value that the city has received.
So there would be no binding contract, but you're saying that Richards in this case would be entitled to be paid on a quantum merit basis.
No, I'm not saying it wouldn't be a binding contract. I'm not saying that. I'm saying that if the council would not pay, Richards would have a cause of action to go to the court to let the court decide whether or not it should be paid and how much.
But you're saying that, and what would the court have to look at to decide?
The contract, the breach of the contract.
I get it, but if that's true, then the council has no discretion here. If the mayor, under your theory, if the mayor signs a contract, the council can either approve the payment, or if they don't, they're going to get sued and they're going to have to pay anyway. So the council really has no role.
Really,
you erase the role of the city council.
Really, what would happen? The county would have a role in that, because the court might determine that Richard is not entitled to anything under that contract. And again, Your Honor, I'd like to point out something too. Everybody keeps talking about the council's approval or disapproval, but the council approval or disapproval is not limitless. It has to be based on good cause, and it can't be arbitrary and capricious. And that's what's happening here. That's why we have this situation.
Well, you may or may not be true. I don't address that question here, because that's not part. The mayor hadn't asked me to declare that the contract was not arbitrary or capricious. He just asked me to declare what the procedure is, which is.
He does say something about subject to the council approval. And if it's going to be subject to the council approval, I think clarification should be made that the council's approval is not unlimitless.
Well, any action by government that's arbitrary or capricious is always subject to judicial review. I agree with you on that. But all right, so we've gone through everybody. Would any of you like to respond to any of the things you've heard, or add something to what you provided to me tonight?
Your Honor, this is Chase Bryan for Waste Management. I've got one comment to make, if I may.
Certainly.
I don't think the approval or lack of approval of the emergency contract back on September 30th, 2021 has anything to do with this, but that was approved in the minutes, or recently approved by the City Council. So it has been approved, and based on the AG opinion, that approval relates back. So to the extent you care about that, I don't think it's relevant, but those minutes have been approved.
Okay.
Your Honor, point of clarity, this is Tori Martin for the City of Jackson.
Yes.
That's just not true. So the September 30th, can you hear me, Your Honor?
I can hear you fine. Yeah, just fine.
Can you hear me? Our system went out. Can you still hear me?
I can hear you fine. Yes, I can.
Okay, I'm sorry. I have to hit the button on the screen. It's virtual.
That's okay.
Anyway,
no problem.
So what I would submit to Your Honor as far as the facts is that the September 30th was an order declaring an emergency. That is what went to the city council on September 30th. Or no, they didn't even go to the city council. For what it's worth, the September 30th declaration of emergency was an executive order. It never went to the city council. The emergency contract with Waste Management did not go to the city council until October 26th. So on October 1st, Waste Management started providing services to the city of Jackson under the 6-month emergency contract. But that contract was not ratified by the city council and arguably might still not have been ratified by the city council based on the arguments of Richards, because those minutes have not been finalized. But
that's not before me, is it? I mean, that is
correct. I don't disagree with you. That's not before you, but I just want to make sure the record is accurate in stating that the September 30th was an order declaring an emergency by the mayor. That was an executive function. That the contract with Waste Management, the emergency 6-month contract, did not go to the city council until October 26th.
Okay, I get it.
And those minutes have been prepared and approved as we understand it. But anyway, I don't think it's relevant.
I don't think it's an issue that I'm called upon here to decide. So
I agree.
It's that contract, for whatever it was, is over and done with, and is not before me now. Except to the extent that it, if somebody wants to argue it, provides some kind of pattern or something, but I don't see that. I'm looking at the law, the statutes, and the Constitution to try to decide what is possible to be done here. And I think you all have kind of gotten a notion of what troubles me and what I'm looking carefully at. I'm certainly willing. Anybody else got anything else to add or clarify? Okay, well, look, I really appreciate everyone's willingness to come out tonight and help me with this rather than in the daytime, and especially over Zoom since we had some terrible weather. I'm going to consider the arguments I've heard tonight and everything that's been filed. As I recall, there are a couple of motions pending. One was to dismiss city council members individually or something. I didn't view this lawsuit as including any claim against the individual council members. And so I'm not sure they are defendants in need of dismissal. So y'all can help, whoever are the parties that are involved in that can help me understand it by separate email if you like, and I'll take a look at it. And then the second thing was the issue of the intervention, and I have asked for an order clarifying my orders of allowing the intervention of the 3 intervenors, provided that the intervention is limited to the issues that are raised in the initial pleadings by the mayor and the council here. I can't expand this case at this point. That doesn't mean that, and I don't know where this is going yet, but it doesn't mean that it's not possible that on motion of one or more of the intervenors, I might expand it, but not now. Now is the time I am trying to address the issue before me raised by the mayor and the response of the council, so that because I believe the mayor is entitled to relief on what he's asked for, and expeditiously. And then if it needs to go further, then we'll look at it at that time. I know there's a separate lawsuit. Can anybody report to me what the status is of this lawsuit filed? I think it was filed in the circuit court, and it was a injunction case. Tell me who filed it? Did the council file it?
No, Your Honor. I filed it on behalf of the mayor. That was the petition for writ of mandamus to get the court to order the city council to transcribe and follow the authority with respect to the minutes. I raised that issue before.
All right.
At the time that
what is the status? What's the status of that?
we have a hearing in the morning before Judge Peterson at 9:30. If the court will recall, in that I represented, informed the court that when we were studying the file, we realized that the city council had not had any official minutes since, I believe, September of 2021.
Right.
And so today we gave the court an update, the circuit court. I don't have that particular file in front of me. Since we filed that suit, there have been numerous emails about some minutes, and some minutes have been submitted to this department or whatever, but I can tell you that the minutes have not been presented to the mayor like they should. So we're going to appear in front of Judge Peterson in the morning. And
all right, if you can, I would appreciate if you'd keep me updated on the status of that case, just so I'll know. I don't want to get into any contradictory situations unless it's just unavoidable. So if you would, let me know what the status of it is.
I would. And if I may, Your Honor, you also mentioned the order, amending your prior orders, allowing. Yes. That was submitted to the court this afternoon with an attachment with some other things. So you did receive it. You may have not had a chance to look at it.
I have not had a chance, but I'll take care of that tonight or first thing in the morning. All right, everybody, I know it's late. I do appreciate it very much.
Justice.
Yes.
Just another second.
Yes.
The motion to dismiss council persons Lee, Griselle, and Lindsay. Council, independent special counsel explained to them that, look, y'all aren't named individually. You all are covered under the State Tort Claims Act, sovereign immunity. You're acting under the color of title in your own official capacities. They still requested, and I'm a good lawyer, I do what I say, and I do what I'm told by my counsel, by my clients, but I needed to produce that. But Judge, you can take that off of your list of things to do. It's not as pressing.
Yeah, Mr. Martin, why don't you do this? Why don't you prepare me an order that denies the motion to dismiss them based on the court's view that they are not parties and that they enjoy the protection individually of the Tort Claims Act. If you'd provide that should satisfy them and get this lawsuit in proper form.
Yes, sir. And also, sir, Judge, may I have at least 24 hours? I have
all the time you need. It's not time critical.
Yes, sir.
Take all the time you need. It's not time critical.
Yes, sir.
All right. Anybody else?
Nothing on behalf of the mayor.
All right. Thank you all for your courtesy and for your participation tonight. And if any of you, I don't stand on the formalities of motions and hearings and all of that. For if any of you have something to add, if you have a case you want to present to me or some clarification, you don't have to prepare some formal pleading. You send me an email, copy everybody on it, attach the authority, and if Ms. Green, if you want to send me that alias against Oxford case attached to an email, I would appreciate it. You can just copy everybody on that, and I'll be happy to receive and read anything you send to me as long as you copy all counsel on it. So with that, we'll recess until we're later convened. Thank you all.
Thank you, Judge.